Welcome back. First, I will look to Ms. Cott. Are you ready for us to go back on the record?
Hi, I'm just going through my notes here. Mr. King, chromium insuffluent. I couldn't figure that one out.
You're
Oh,
on mute, Mr. King.
Uh, the hexa, there's so I talked about the affluent, the chromium effluent, like effluent, EFFLUENT.
it just sounded like you were saying insuffluent or something.
Okay, there's trivalent
Yeah, I got
with,
that.
and then hexavalent,
I got
HEX.
that one too.
Yeah.
I was stumped on the insuffluent. So if it's just effluent, then
Maybe effluent, yeah, or
okay.
mumbling within that. So, yeah.
Okay, thank you. I'm all set.
Thank you. All right, welcome back. I will orient us for the recording. It's October 10th in the afternoon. We completed this morning the hearing case in chief testimony from Mr. King. We also heard the remaining portion from Mr. Asarian. We had talked briefly before the break about setting deadlines for evidentiary objections and how we would structure those. And Mr. Hitchings hopefully circulated from his team a proposal, which I hope all of you had a chance to look at, and I had a chance to look at with the AHO team. I would like to hear from all of you if you have different suggestions or comments about the proposal. I'll let you just a little background on what I'm thinking in terms of what these motions would look like. I have in the past received motions, especially when there are a number of evidentiary motions that are submitted in a table format, and I find that to be particularly helpful. I think it disciplines all of us to be more brief, including my own rulings as well, because you have to fit it in the table. So I would ask for that. I mean, if for those, especially for those of you who are familiar with that formatting, of course, there may be certain types of objections that I leave it to your discretion that don't fit in a table, but I would encourage you to use the table format. I also would be inclined, depending on, to allow for oral responses if that's preferred. But I'd like to hear from all of you on that I wouldn't require any responses to be in writing, that I would allow for oral responses, but that does mean we would have to schedule that. I think some of that could be handled on November 4th. Maybe all of it could be handled on November 4th, depending. But those are the two thoughts I had without getting into the rest of the merits of this. And I will look to the room. Put myself on gallery here. Mr. Busher, would you like to jump in?
So I have a couple of questions that I think would be helpful in understanding and coming up with a schedule here. One, for the AHO exhibits, are those automatically being moved into the record to the extent parties want to rely on them or object to them? Do we need to do that as part of this process?
We do need to do that as part of yes, we do need to add that. So that's a good note. The AHO exhibits are not, they will be offered into the evidentiary record, but there may well be objections to, you can raise objections to parts of them, all, particular exhibits or even relevance. We mark them, as I said, we mark them as AHO in an attempt to be helpful so that we would have, the common documents that others, many of the parties may refer to.
But so that to the extent that we have objections to any portions of those documents, that needs to be part of this process.
Yes.
Okay,
Yes.
thank you. That's helpful. And then, Ms. Kinsey, I appreciate your, I don't know, thought to perhaps do some or all of the responses orally at a hearing as opposed to in writing. That's really the biggest concern that I or we as the NGO group have, and others can chime in here. But and maybe Mr. Hitchings can disabuse me of this notion, but I expect that there will be a large number of objections that we will be responding to as part of this process, in addition to the scope or relevance objections that have been raised as we've gone through. And I'm just concerned that having only 7 days to do that is not enough time. I'm not sure that through the 4th, even if we're doing that orally, is necessarily enough time. And I want to be a little bit cautious with how much time we're going to have available on the 4th. I expect that the cross-examination for Dr. Rosenfield is going to be fairly substantive, and on the longer end of the ones that have been performed by the site's authority and others so far. And then we have Mr. Ornbaum's testimony as well, and I'm just not sure we're going to be able to get through, right, like, 245 objections on the 4th, no matter how efficient we are. So I think our suggestion would be to provide for more time than Mr. Hitchings' proposal contemplated to respond in writing. And if you don't want responses in writing and just want to do it orally, to plan to have that oral, or that, I don't know, evidence hearing, I guess, at the end of November rather than the beginning.
So if I can ask for a point of clarification, Mr. Busher, is the preference from the coordinating NGO parties that that responses to the objections be made orally or in writing, or is there no preference?
So I don't want to speak for others. We did not
Okay.
discuss this. We discussed
Fair
the
enough.
timing of those objections. I think part of it just depends on how many there are, candidly. I mean, and how duplicative they are, right? If they can be separated into big groups and done in writing, I think there's a lot of benefit to that. I mean, I'm also, right, approaching this as a lawyer who did a lot of trial litigation and summary judgment litigation where you just wade through hundreds of these in writing and, it's all done on the paper. So I'm a little bit agnostic as to the approach, so long as there is, sufficient time between when those objections come in and whenever those responses come out. Yeah, I'll defer to others on that. I'm a little bit agnostic.
I'll continue around the room. I don't know whose hand went up first, but Mr. King.
Just let Mr. Mooney go first because it probably is related to what Mr. Busher said.
Okay, Mr. Mooney. You're on mute.
There we go. My thought is that if we have lots of written objections from sites, and again, we don't know what that's going to be, but from the amount of objections they raise already, I suspect it's going to be, it'd be nice to be able to put the responses in writing, at least if it's, kind of in a table format. And my thought is that even if we do it, just orally in response to the hearing, we're going to have gone through it all and make our notes and make our notes and do all that. And if it's in a table format, we might as well provide you, the hearing officer, the benefit of what we have already written down, because we're not going to just come in cold. But we do need, I know personally from my own schedule, I need more time than a week if there's going to be numerous objections.
Thank you. Mr. Reese.
Good afternoon. Yeah, I think they're probably ultimately going to be in writing, and as long as they're in the table, I think that'll help organize. I know myself and everybody else probably, but certainly I would agree with that. And we need much more than a week. I would suggest 2 to 3 weeks to respond.
And just following up on that, the request for an extension of time for a response, that puts us up against December 6th. So part of my question is, how important is it to you that you know what evidence is in or out for the case in chief for purposes of submitting rebuttal evidence? And I can go around the room again, but also since you're off mute,
Right. That is important. That's a good point. With that, and I think there was some discussion of that yesterday. I think that would beg the question as to whether or not the December 6th deadline should be pushed out some, and I think it should be, because it is important to know what evidence is in and what isn't.
All right, Mr. King, I know Mr. Busher, I'll circle back to you too, but let's hear from you, Mr. King. I know we've deferred. Is it on this scheduling issue?
Yeah, yes, it is. And so, my preference, especially since authorities objected to all my written testimony, my testimony, is to do it orally, and I'd be happy to do it on the 4th. I'm really just going to rely on your discretion, and you can decide what should be admitted or not. But I really don't really want to do a line by line of everything and spend the time on the putting them in the box and everything. At the end of the day, it's really going to be up to your discretion. I really approach this as a kind of a hearing, and um, and frankly, I feel like the most important thing is conditions that you may impose on the authority and what type of adaptive management measures may be needed to make sure that things aren't externalized. So I'd appreciate it if could do it on the 4th if there's time, and we flesh it out orally with the authority. And I'm assuming nobody else is going to object to my testimony also. So
Unless there is a objection that I haven't heard yet, I think it would be just fine for you to respond to any evidentiary objections from the authority orally as time allows during the hearing on November 4th. Mr. Hitchings, do you have any concerns?
I'd like to say one more thing. I'm not gonna object to anybody introducing anything into this proceeding. So I believe people should have the chance to introduce what they want. Thanks.
Mr. Hitchings, do you have any concern about that approach for Mr. King?
I have no concern with him not objecting to anybody else's evidence. And no, if Mr. King prefers to just submit his objections in verbally, we have no concern with that. I mean, I think hearing what I've heard, and I think we were trying to balance all these things as far as, wanting to have the AHO the opportunity to rule on this before sufficiently in advance of the rebuttal hearing date, and kind of given or not hearing date, the testimony deadline due date, maybe a way to address this, and then also be able to accommodate Dr. Rosenfield and Mr. Ornbon's conclusion of testimony, which hopefully that can be concluded on the 4th. I think Mr. Busher is right. I think a lot of the time of that day will probably be taken up. So maybe what we could do is do something somewhat in the middle of what we've suggested, and perhaps everyone can have, if they care to submit written objections in table form, maybe do that by the 6th and then, or the 7th, and then have the opportunity to have a oral or a hearing day or a portion of a day on this on the 8th or the 12th or something like that. I'm concerned going all the way to the end of November, that doesn't address the issue of wanting to have some clarity on this prior to finalizing rebuttal testimony and exhibits. And I think that seems to be a pretty good compromise to extend the date out a bit, but address the issue with rebuttal.
Now I'm confused. I'm sorry. Let me. But which date are we pushing out?
I'm saying it sounded like there's a concern of having responses to objections on the. So what I'm saying is have the objections lodged maybe on an early or kind of the schedule that we had. Do some modifications, and I'm just doing this on the fly right now as I listened to all this. So, but what I'm saying is that as far as the issue with responses, all written responses would be due on, say, the 6th or 7th, and have a hearing day shortly after that, and maybe we stagger when objections need to be lodged, similar to our earlier proposed schedule.
Right. I'm not sure. So other than Mr. King, we may not need, although may not hurt, but we may not need an actual hearing day. It sounds like there's a general consensus to other than Mr. King, do this on the papers, but I will go around the room again. So let me go back to you. Mr. Busher, do you have thoughts on where we are?
Um, two thoughts here. One, I guess I'm a little bit skeptical that even under the kind of proposals from Mr. Hitchings earlier and now, and with the caveat he gave that we're kind of all doing this on the fly, right? That there's going to be rulings on all of those evidentiary objections far enough in advance of December 6th for it to be kind of make a meaningful difference. Right? I mean, if everything's submitted to the hearing officer by the 15th and then turned around within a week, right? That's the 22nd. We've got then 14 days, including the Thanksgiving holiday before rebuttal evidence is due. And that just doesn't provide very much time to incorporate or, refocus resources or arguments or anything else for the rebuttal. And so I think that dictates pushing that December 6th date back some, because I'm just not sure that there's a way to get all of this resolved meaningfully in advance of that date, under any of the kind of schedule that people are talking about. And given that December 6th date was set when rebuttal hearings were scheduled to start, I think the second week of January rather than the third or fourth week of January, there may be a little bit of extra room in December to accommodate for some more time there to allow responses or incorporation of the resolution of these evidentiary issues. So that's my first thought, just kind of generally. And then the second, I'm still, even if the responses to the objections are pushed back to November 6 or 7, right, that's still less than 2 weeks of time from when the bulk of those are going to come in, for all of those witnesses. And I'm just skeptical that that's enough time, and don't want deadlines that we may not be meeting anyway, to be driving deadlines that are ultimately unworkable for the parties. So I think that's from our perspective, I think the best way to handle that is to provide a little bit more space for the rebuttal deadlines. That gives more time to resolve the evidentiary issues now and ensures that the parties can have sufficient time to respond to all of the objections that are raised.
Do you have, Mr. Busher, do you have any objection to October 25th as the deadline for submission of the bulk of those, of the evidentiary motions themselves?
No, I don't think we do. I mean, I think that's fine. I don't expect that Baykeeper will have, and probably many of the other NGO parties will have a huge number of objections. So I'm fine with the submission on the 25th. I would request and recognize this is a little bit difficult, but if there are scope and relevance objections that are coming in to witnesses like Dr. Rosenfield, similar to the ones that have been noted on the record for other witnesses, it seems like those could be made by the 25th as well, recognizing that there may be additional objections that come up once he's testified, and I don't intend to preclude sites from offering those, or making those, but the more of it we can get on the 25th, the better, and the more time we'll be able to, have to then respond.
Right, understood.
Thank you for indulging me.
Yes, no, and I am also thinking about this on the fly, and looking at my calendar and looking at all of you. Let's see, where are we? But Zoom tells me you're next, Mr. Hitchings. Does it make sense? Let me hear from Mr. Mooney and Mr. King, and then I'll come back to you, Mr. Hitchings. Mr. Mooney, please go ahead.
You're muted.
I was just going to confirm that the 25th is fine with us for the submission of that, and we don't. I mean, we may have a few objections, but we don't necessarily expect a big long list of objections from us.
Thank you. That's helpful. Mr. King.
Yeah, so regarding myself and Mr. Ornbaum, I would think that he wouldn't want to submit something in writing. I think it'd be really difficult for him. So, if everybody could I'm assuming, if there's other objections to my testimony besides the authority, if that could be known sooner rather than later, but also I would imagine the authority already has their objections to Mr. Ornbaum's testimony, and if those could be communicated to him as soon as possible, perhaps you could let Mr. Ornbaum know that the admissibility of his testimony and whatever exhibits would be also part of that same hearing or hearing with me on the 4th. And then that way it takes those two parties off the table, and that'll be, settled, or at least you'll make a decision after that hearing. So I think from, I'm assuming that Mr. Ornbaum doesn't want to put it, have to actually submit stuff in writing based off his past actions. But, I just think if we can know what our objections are to myself, and then maybe perhaps Mr. Ornbaum, it's a way to handle it both on the 4th.
That's a little challenging because some of the objections may be based on Mr. Ornbaum's cross-examination. So that may not be possible, but we can thank you, Mr. King. I recognize the issue there. If necessary, we could schedule a very brief, well, we'll see. We'll see if we end up with a separate evidentiary hearing day. But thank you, and your comments are noted. Mr. Hitchings, back to you.
Yeah, thank you. I think maybe a good solution to this would be, and particularly given that Mr. Bush or Mr. Mooney indicated there was no issue with lodging objections that they may have for sites, is we will submit all of our objections by the 25th with the caveat, and this would include South Delta Water Agency parties as well, or South Delta parties, Delta Water Agency parties, sorry. With the caveat that we would have the ability, if we feel there's a need for any supplemental or additional objections to make after they complete their case in chief, same with Dr. Rosenfield and Mr. Ornbaum, but otherwise we will submit the objections that we have by the 25th, and subject to kind of just a reopener on those additional parties since they haven't concluded their testimony. And I think that then, helps everybody with what we thought it was going to be more efficient to stagger this, but clearly it apparently is not. So that might be a good way to solve some of the different competing interests that we're juggling here.
Thank you. I appreciate that.
And we'd be in agreement with that.
Thank you.
And one other thing I'd like to note is that we don't believe it's appropriate that, the issue with regard to evidentiary objections should be driving the rebuttal schedule. We were trying to address that competing interest to have some rulings on this, but we don't really want to affect the overall schedule to deal with these evidentiary issues. So that's really what we would request. I know the hearing officer, you had said that you were going to possibly revisit and putting some of those dates back on the schedule for January. But that still might accommodate a slight extension in the current December 6th rebuttal testimony deadline. But we don't think it's, we're not supportive of, having a wholesale schedule change that is significant to what the rebuttal schedule is now and what's been indicated as to what might be contemplated.
Thank you, Mr. Hitchings. Mr. King, is that a new hand or a residual hand? Do you have something else?
It's a new hand, yes. So I was just thinking about from a sequencing issue. First of all, regarding objections to Mr. Ornbaum's testimony, and I appreciate the authority saying they're going to have all objections by the 25th. If those possibly could be communicated directly to him so that he knows that, rather than I think that would probably help in anticipation of his testimony. But also, perhaps you may want to schedule his testimony first thing at 9 a.m. on the 4th, and then do Dr. Rosenfeld. So that would allow people to make any additional objections to be, considered by Mr. Ornbaum during the time that Dr. Rosenfeld is testifying. And that might just help resolve the issue between myself and Mr. Ornbaum on the 4th. So just a thought.
Thank you. Noted. We have a little time to think about that later too. So here, Ms. Altenberg, please.
Yeah, thank you. I following to the extent that I've heard the proposal by the authority to make the deadline the 25th. I'm unclear about what that does to getting a ruling, because I'm sensitive to the Mr. Busher's statement that the ruling affects the rebuttal quite a bit.
Excuse me.
And
And we're, yeah,
sorry.
sorry.
Go ahead. I was just going to clarify because
okay, thank you.
So I heard Mr. Ruiz say that. I understand the logic behind it. And I don't want to put words in Mr. Hitchings' mouth, so maybe it's a better question than a comment. But do you think you need the resolution of the evidentiary issues before the rebuttal testimony?
I think there may be portions of the testimony where that'll be important, but I think we can also adjust if there's a ruling somewhat in advance. I had just heard in prior discussions on the evidentiary issues that was a concern of some people and possibly even the AHO office. So we were trying to just address that interest. But I think I would expect that most of us are preparing our rebuttal testimony. We know the key points that we feel we need to present rebuttal testimony on and present exhibits. And I don't know whether there'll be a large scale change in that from any rulings that would come out.
So, and I'll speak just for Baykeeper here. I don't want to speak for anybody else, but like Mr. Hitchings said, I think I'm not sure it's particularly likely that the resolution of our objections certainly are going to make much of a difference for our rebuttal testimony. And if that means we have more time to resolve the evidentiary objections, right then I would suggest taking that and spacing this out. I think under anybody's conception, they'll be resolved well in advance of when the hearings actually start for the rebuttal testimony. Even if that testimony is submitted on the 6th or the 13th or whenever in December we land on. And so that just may give us a lot more time to resolve these evidentiary objections if we don't think they have to be done by the 6th. And I understand why, but I'm not sure that is what should be driving the timing of any of this. So.
Thank you. I appreciate that, Mr. Busher. And Ms. Alftenberg, I don't know if you had something else to add. We took your comment.
Sorry. Yeah. And I'm not talking about a huge, I just am thinking about you preparing testimony for evidence that is then struck, and then what does the status of that testimony after that? Then I guess we can figure that out on the next round of evidentiary rulings, but that's all I was thinking.
Understood. Yeah, thank you. Mr. Schutz.
Yes, I had a couple of sort of practical process suggestions or thoughts. One was if the objections are going to be submitted in table form, if there's some way of not having to reproduce from one table into another table in order to make your response, that would be convenient. That could be done by submitting a PDF perhaps, but also a Word document that had a space on the right in order to provide a response. I find that more convenient than Excel personally because of the formatting issues with Excel. But that might be a helpful way to expedite the response in writing. And then the other issue was, I'm wondering if there might be some value in addition to asking for written responses to also hold a part of a hearing day to discuss any objections and responses to them, because sometimes those are more quickly and efficiently and perhaps clearly resolved in discussion or in a back and forth kind of scenario than in a series of written objections and responses. Thanks.
Thank you. So both good thoughts, but particularly the Word document stood out to me as probably a good idea. Are there other, I'm formulating a concept here, but are there other comments at this time? What I think it sounds like we have consensus on the October 25th as the deadline for submitting written objections to evidence. And if you would please, to the extent possible, submit them in, that's appropriate, submit them in chart form. And I like Mr. Schutz's suggestion, both in PDF, but also in a Word document form that then can be used by both the responding party and then frankly the AHO to provide a ruling. So when you submit your responses, if you would also include those as a Word document, then we can just add to this living document. I think that might work well, just as logistics. So I appreciate that. What I'm thinking with deadlines for responses in writing, I was looking at the week of the 12th. That I believe is about 2.5 weeks from when we'd receive, if my math is correct, then when we receive the motions. And then I was also considering, I think we can push back the rebuttal exhibit deadline by a week without affecting what I'm considering for January dates. I am considering putting some of those, the mid, that would still give us at least a month before we resume the hearing in January. And that could give a little more room there. In terms of setting, and I'm going to ask for comments on this proposal, but in terms of setting another hearing date sometime to hear on these evidentiary rulings, if for the responses the week of the 12th, I don't know if we do it the 12th. I was just looking in that week. We'd have to do it the next week, otherwise we run into Thanksgiving. And things get difficult. I don't know if that's, I agree with Mr. Schutz that sometimes that can be effective, but it also is sometimes a scheduling challenge to, especially around Thanksgiving, to set up time to do these things. I think we could accomplish it on the papers, and to the extent there were any residual, really difficult residual evidentiary issues, then we could we could talk about it on the 4th. We at least would have the motions in by the 4th. So we could revisit whether we want to schedule a hearing day in mid-November, mid to late November. Does anyone care to, Mr. Hitchings, would you like to comment on on my comments so far?
No, I think we're generally comfortable with rulings on the papers as they're submitted. And if you believe that there's any particularly troublesome or more difficult evidentiary objections and responses to address, then we hold a hearing on that limited set. But I mean, I think we would leave it obviously to your expertise and judgment as to what you need to hear oral argument on and what you don't. But I do think, as I understand it, you're saying that responses to objections, written responses to objections would be due on November 12th, and absent, they would be submitted on the papers otherwise, unless you otherwise indicate that you want to hear, have a hearing on any of the issues that you specifically identify, where if that would be helpful to your decision.
Right. That is I think that accurately summarizes.
And I guess the one caveat, as far as just, if we feel that after the Delta Water Agency parties are concluded, let's say they do finish on the 23rd, we may need a little, if there's something new that comes in there, we'll do our best to get that into our objections by the 25th. But and then obviously anything that may be new as a result of the testimony on the 4th, we would want a little bit of time to be able to provide that in writing after that, so that responses could still all be due by the 12th. That'd be a very limited subset of evidence to deal with, I think.
Understood. And if that comes up, I mean, what I would do is I'll likely ask you on November 4th whether you anticipate having any supplements so that we can set appropriate deadlines if that comes up.
Okay.
I know it'll be a quick turnaround, but I think you will know. Mr. Rees.
You address it. I was just going to say, we need to know after we're done and the other parties are done on the 4th, if there's going to be a new deadline for supplemental objections. And then Mr. Hitchings mentioned or stated the 12th. I think you mentioned the week of the 12th. The 12th is a Tuesday. I don't know are we picking the 12th or the week of some date, the 15th or the 11th. I don't know.
Not the 11th, because that's a holiday. So
okay.
it's either, that's why I said the week of it. So November 11th will not be November 11th, but I'm proposing the 12th unless there is a request for, well, I mean, I think the 12th makes sense here because that gives me a little time to get a ruling out.
Okay.
Yeah, that's what I'm looking at. It is a Tuesday, but it's not Monday, the holiday. Mr. Butcher, go ahead.
Yeah, I was just going to ask in terms of the week of the 12th, we would ask for, I'm going to ask for the 15th. I think if you want it by Friday and we need to work on it on Friday, so we need to submit it by Thursday, we can make that work. But we're going to be, there's a little bit of like a mismatch, right? Sites Authority has one set of counsel and, one set of people who work for it, right? That they can all coordinate together at once, right? For our group, that involves getting, right, 10 or 12 or 14 different organizations or tribes together, right? Each of whom offered or sponsored different portions of the testimony, right? Some of whom are represented by different counsel. And so there's just a lot of logistical work that goes into, right, trying to prepare on all of our entities' behalf, right, a single consolidated response to objections. And so if we're going to do the week of the 12th, we just ask that it be Friday the 15th or Thursday the 14th if your office needs it before Friday.
Thank you. Mr. Mooney, you're on mute.
There, I was just going to echo that because I hate having things due on a Monday or after a 3-day holiday, because then it's not really a holiday or a weekend. So if at all possible, I try not to have things scheduled and just maybe able to still have that family time and such. So anyway, that was my thought.
Well, and you anticipate that. Here, how about this? Let's do. It'll be due the 15th. Friday is fine. Do the 15th on Friday. If you would please, here's the caveat. The sooner you get your responses into me, the sooner you'll have a ruling, at least with respect to your evidence. So there will be no difference in my objective assessment on your motions by getting it in early. However, you'll get a gold star, and I will try to get those out as quickly as possible and back to you. So you are welcome to submit your responses before the 15th, but we'll do a deadline of the end of the day. That's midnight on the 15th. So to the extent possible, all evidentiary objections, with the caveat that there may be additional issues based on testimony that we haven't heard, will come in October 25th. Responses are due November 15th. And then associated, the deadline for rebuttal exhibits will be December 13th. Are there questions about, I will memorialize this in writing in a written ruling for all of us. I think what I'll do, I'll try to get this out quickly so it's very clear, but I will do it probably with an amended, I don't know what number we're on, 5th amended hearing notice. So we'll have that. Are there any other questions or concerns about this piece? I would like to talk briefly about the order of witnesses for the South Delta water users, those interest groups. Mr. Rees, can you just provide me an order of witness? I mean, you may have already provided this. I just don't have it in front of me. Can you just tell me?
Sure.
Please.
The plan is Tom Burke, followed by Greg Wilson, then Dante Nomalini, and Bruce Herbold, and then Joe Ratto and Richard Pellegri, the two farmers sort of together.
Great,
And,
thank you.
and if possible, I mean, I don't know how long, or maybe we'll get an idea what the cross estimates are, but Mr. Ratto, Mr. Pellegri are farmers, and Zoom is not, or well, I shouldn't stereotype farmers, but for them, Zoom is not something that means anything to them. So they're going to be coming into my office and lingering around. So I'd like to sort of maybe say we could put them on, you know, the 22nd or something first thing, or, you know, not or right in the middle of cross on another witness, but maybe set them rather than hanging around all day on the 21st, if maybe the 22nd makes sense for them.
I can understand. That makes sense to me, but I'll look to, thank you, Mr. Reese. I don't know. I realize we're out, you know, we have our bye week here. So you may not, Mr. Hitchings, know, and you may not be doing it, whether you're going to have the extent of cross-exam for each of these witnesses, but do you have a guesstimate at this time that you can share?
I don't think we do quite yet, but we can send that guesstimate out by the beginning of next week,
Great.
by Monday. And we still have on the 21st also Mr. or Dr. Khan and Asarian. So that'll take up probably, you know, that may take the morning or most of the morning with their direct presentation, and then the cross of them. So, you know, we're really only going to probably have a half of that day for the Delta Water Agency witnesses.
That makes sense. Understood. And do you have any concern about fitting in the two, I only got their first names, farmers, as Mr. Reese referred to them, on as convenient on the 22nd, basically? I mean, if we're in the middle of cross, we'd wrap up where we are with that witness and then going directly to them. Do you have any concern about that?
I don't think so. And I don't know if it messes up Mr. Ruiz's order, but if they want to be slated for the afternoon of the 21st, that works too. But I don't know if you wanted them to go. It's better for your case to have them go after some of your experts do.
Probably, yeah. I'd like to have them go at the end, but I had forgotten about the morning of the 21st. I mean, I would think that, well, we can see what happens, but maybe it's even a situation where they're the morning, the farmers, Mr. Ratto, Mr. Pellegri, or the morning of the 23rd.
I think it's shaping up to look that way.
Yeah.
As we sit here right now, at least. Yeah.
I agree. At least I can tell them, I think it won't be the 21st or 22nd. Also, we can revisit it obviously on the 21st, but I would think that they won't be going to the 23rd.
That seems right.
Right.
Thank you. Thank you to both of you for coordinating. Are there other procedural issues we should address before we break for a week and then come back on the 21st?
So,
Ms. Aufdenberg.
Sorry, I know Mr. Hitchings said he would get his estimated cross of South Delta by Monday. Monday is a federal holiday for us, and are you expecting everybody to have sort of the same guesstimate?
Monday is a federal holiday.
What holiday?
Let's see. No. Well, it would be great if we can have a guesstimate. When would you like to offer that guesstimate, Ms. Altenberg? Not Monday. Don't do it Monday.
Yeah, and I probably would need until Wednesday.
Okay, I think that's still well in advance. So let's ask for guesstimates as soon as possible, but no later than sometime on Wednesday.
Okay.
Thank you. I appreciate that. Mr. King.
Yes. So I just wanted to I wanted to make the point that I mean, this is probably just administrative comment, but you asked about the riparian rights. I forgot to mention that there are two actually State Water Resources Control Board decisions that affect license application 12459. One is decision 683 in 1950, but also there's decision 747 in 1952.
Mr. King, I think this might be excellent for rebuttal.
Okay, that's what I thought you might say.
Thank
There,
you.
there you go. Thank you.
Mr. Busher.
I was just curious if you or your office had an estimate for when or whether any different January rebuttal testimony dates would be set. I know that there was the original one set, some of which didn't work, and then the amended notice or the fourth amended notice has us starting on January 24th. And I thought I heard you say that there may be some earlier dates added back in. And I'm just trying to
Plan.
plot out my, Q1 2025 and make sure that I have the right dates held on my calendar. So do you know when that determination will be available?
Well, let me tell you what I'm thinking about, because so what had happened was, as a little backup, Mr. Hitchings had informed our office, all of us, that he would be traveling, which sounds lovely, and out of the country in parts of January. I think I just misinterpreted the request to be a postponement of the rebuttal until the 24th, which is reflected in the corrected fourth amended hearing notice. I think I misunderstood that, and then Mr. Hitchings and I had an exchange that other members of his office are available for most of the dates. Or I should say some of the dates that I had canceled. So I was considering putting back on the calendar, strongly considering putting back on the calendar the 14th, 15th, and 16th. So I'm not considering starting sooner than the 14th, which is why I reflected that this December 13th deadline for rebuttal would still give us a month. But I am considering adding back that 14th, 15th, 16th, those days. Understanding, Mr. Hitchings, is that other members of your team would be available to cover on those days. Is that right? Yes, nodding yes. So Mr. Busher might.
Yes, sorry.
That's okay. Nodding works. I would plan to make that. I also think I need to add some February dates, because we are taking a few of those rebuttal dates off calendar. So I was going to look. I hadn't gotten as far as looking at February dates, but I think when I put out in writing and memorialize this October 25th deadline, which is soon. So sometime next week. The short answer is I don't think I'll get it out tomorrow, but my intent is to get out a fifth amended hearing notice next week.
Okay. And is it, I don't want to assume, but is it right that then the 20th and 21st are unlikely to be added back in, at least as
the 20th? I believe the 20th is a state of California holiday. It may also be a federal holiday. So that will not be added back. And the 21st, there was a conflict with the authority. So my intent was not to add the 21st back in either. Yes, that's correct.
All right. Thank you. I appreciate the estimate, at least.
Yes, thank you.
One suggestion, Hearing Officer Kinsey, is given how things had shuffled a little bit in those January dates, I would suggest that maybe you do add a date on the 23rd. See if we can get as many dates in January, and that might cut down on the number of days you need to add in February. Otherwise, right now, I think we only have one day in that week of the 20th. I think your current schedule didn't start till Friday, so maybe add back in that Thursday, the 23rd, or add that.
Yes, thank you, Mr. Hitchings. I was considering that. I was going to check, and all of you can check too. It's scheduled as a board workshop day. I just wanted to make sure it wasn't scheduled for a Bay Delta item where we'd have a lot of conflicts. So I need to check that. But I am considering putting the 23rd on, so we'd have the 23rd and 24th that week. Mr. Mooney, you're on mute.
I'm just trying to schedule some hearing dates at the end of the month in an unrelated matter. So if I do the 21st or 22nd, I would be relatively safe on that.
I think the answer is yes. Let me look. Let me make sure I'm looking at yes, that is correct. I can commit to that. will not overlap with this hearing.
Thank you.
Thank you.
And Ms. Kinsey, you may know more than I do, but on the Bay Delta plan question, my understanding now is that the current hope for the board is to issue an updated public document as soon as this month, and that there will be a series of workshops and public comment opportunities after that. I don't know exactly when that happens or how long that will last, but hopefully those occur between November 4th and when we restart. But
I will look into that.
I understand a bunch of those are about to get scheduled. So
Yeah.
Thank you for
Thank
flagging.
you. Thank you for that. Yes, we do try to coordinate here, but the collective doesn't work perfectly sometimes. Are there any other comments or questions that we can resolve? All right. Well, thank you very much. We have, Ms. Cott, please, something we can address.
Yeah, just the spelling of the farmers' names that Mr. Busher, or no,
Mr. Reese.
Mr. Reese.
Yes.
Last name Ratto, Ratto.
Okay.
First name Joe. Second one, Richard Pellegri, Pellegri.
Okay. And just the other witnesses that you had, I don't have a list of them.
Tom Burke, Burke.
Okay.
Greg Wilson,
Okay.
Dante Nomalini,
Yeah, that one.
Nomellini.
And is Dante DANT?
Correct. Senior.
Okay, thank you. That's all I needed.
Thank you.
Thank you. Thank you, everyone, for your efficiency today and getting through this. And I will see you the morning of the 21st. We are adjourned.
Thank you.
Thank you.